Okay. Hello, everyone, and welcome to the ninth edition of the Dispute Resolution Dialogue series. Today's session draws on a pioneering empirical study examining how Indian courts exercise their powers under Section 11 of the Arbitration and Conciliation Act. Our speakers today will unpack key findings from their research based on data from the Bombay and Madras High Courts between 2016 and 2024, and a series of stakeholder interviews. Their study reveals that arbitrator appointments in India continue to be opaque, heavily judicialized, and concentrated within a narrow pool of retired judges. The discussion will also explore the implications of these trends for party autonomy, efficiency, diversity, and India's ambition to position itself as a global arbitration hub, drawing comparative insights from jurisdictions such as Singapore, UK, and Hong Kong. I'm pleased to introduce our speakers for today's session. We have Mr. Animesh Bordoloi. He is the Senior International Case Counsel at the Asian International Arbitration Center. And of course, Dr. Prashant Narang, Deputy Director of Research and Programs at TrustBridge Rule of Law Foundation. Without further ado, I'd like to hand it over to Mr. Animesh to kickstart the session.
Thank you so much. Thank you to TrustBridge for the opportunity to present our research. Just a heads up, I think this was a part of a project that me and Prashant we were doing a few months back. So it's a great opportunity to work with the organization and now have the opportunity to sort of present what we've been doing. So as you can see from the slide itself, it says about judicialized appointments and the crisis of arbitrator selection. So if we go to the next slide, I'll just give a brief outline of what we set out to do and how far we have come with this. So around the time we were researching in a few things regarding arbitration, around the same time, there were certain statements that were made by quite significant, people in significant positions around the country, mostly people in constitutional posts, one being the vice president of the time and the then Chief Justice of India, who kept on stressing about the fact that arbitrator appointments should come out from the usual course of action, where they end up appointing retired judges. There was a lot of call about young people to be inducted into this whole system of arbitrator appointments, and that sort of raised our curiosity into understanding how the whole process of arbitrator appointments take place and what research could be done to understand this system better. So that was one of the initial inclination. I'll of course go into the more detailed version of it, but the more initial reasons of curiosity for why we wanted to do the research. Moving forward, of course, we'll also talk about the methodology, and after that, I'll talk about what are the key questions that we figured out as to who the court is appointing, why the court is appointing, what is the level of indulgence that the court gets into while appointing somebody as an arbitrator, right? So that's essentially the key questions with which we begin the process or the journey of researching about arbitrator appointments. On to the next slide, please. So if you look at arbitrator appointments in India, there are two very interesting points about it. The first is that if you look at Section 11, it is, of course, it is very, very similar because India is a party to the New York Convention and also follows the UNCITRAL model law, which is sort of where the entire act takes its inspiration from. You will see that the wording of Section 11 is actually very similar to the wording of the UNCITRAL model law. So if there's a layman outside who does not have experience of Section 11, if you read the provision, it appears as if there is nothing wrong with the section. But our experiences through amendments and through Law Commission report dictate otherwise. Like I said, that while the point of curiosity were statements made in public by constitution post holders, if you read the literature, especially with regards to the Law Commission report, the 246 Law Commission report, or the T.K. Vishwanathan high-level committee report, the two documents which we referred to in our study, we will see that there have been either direct or indirect sort of discussions made about why the arbitrator appointment process under Section 11, even if it is similarly worded as the unilateral model law, is a little problematic in the country. And why is it, why should it bother anybody? Will come, of course, with the function of the court, but the larger idea also is that because you are appointing the same kind of people you appoint, and that creates a sort of an artificial demand for that. So it sort of hinders your larger pool of arbitrators who might be better qualified but are not getting appointed. There's a negative idea about the whole arbitrator appointment process, and sort of hampers your ambitions to become a hub for arbitration. But having said that, the first point of focus for us at this point is Section 11. And Section 11.6 is essentially the provision. Section 11, subsection 6, 6A and 6B are the provisions which are of relevance to this entire discussion. The first, like I said, that while different law commission reports and different committee reports have talked about this, the fundamental problem is also that at this point we are not clear. It doesn't clearly state as to what nature of this function of appointment is. You will see a lot of arguments both going for this as a judicial function and also going at this as an administrative function. However, if you read carefully all the literature that is available, you will see that this is not actually defined. The SVP versus Patel Engineering case was one where they said that it is a judicial function. But then if you look at the Law Commission, especially the 246 Law Commission report, they talk about, they do not directly say whether this is a judicial function or an administrative function. So that is one part of it. The second problem, if we go to the next slide, the second problem is that regardless of whether you call this a judicial function or an administrative function, under Section 11, when parties cannot appoint, they have, if you read the language of Section 6, it says that if parties cannot agree on the appointment of an arbitrator, they would essentially go to a court or to an institution designated by the authorities for such appointment. Now, here is where it gets interesting. Now, there's been no designation of an institution directly. In Delhi, of course, as I'll discuss in our study, you will see that the Delhi International Arbitration Center is one such center which takes into account such arbitrations, but we'll briefly discuss that issue as well. But if the institutions, even after the inclusion of the institution, if institutions are not appointing, it is the court who are appointing largely for all Section 11.6 arbitration applications, right? And the problem is this: when you are appointing, if you read the language of Section 6B, it says that there can be no appeal made to such appointments. So that decision is final. So at this point, like I said, that the first problem is that we are not sure whether this is a judicial function or administrative function. Secondly, once the court appoints, the parties have no choice but to go ahead with that arbitrator. The counter argument to this is that many will say that, okay, somebody's been appointed as an arbitrator, but I can challenge that arbitrator once the arbitral tribunal has been appointed. But who are you challenging under? You'll have to challenge the arbitrator in front of the arbitrator itself, because once the tribunal has been appointed, by virtue of the arbitration agreement, any challenges to the arbitrator has to take place before the arbitrator. And this challenge will await, you will have to await for a result. And let's say the arbitrator says that, okay, I don't agree with your arguments, we'll go ahead with the arbitration. So you have to wait for the arbitration to get over till you come back and challenge, saying that, okay, you know what, I did not agree with the arbitrator because at the very first issue, I did not agree with his appointment because I don't think he or she or they are qualified enough to become an arbitrator. So this is like a bird's eye view of the entire issue of appointment, because there is no appeal. A. B, that considering that at this point we are not sure whether this is a judicial function or an administrative function, this is essentially, and the word that we use is that this is a portion where the court has complete discretion with no checks and balances whatsoever. If we go to the next slide, please. So like I said, that Despite the alignment, we'll see that the function is debatable, which is what I just explained. The only remedy or is only qualification, and the other thing is when the court is appointing somebody as an arbitrator, there is absolutely no qualification that they need to look into per the law for appointing somebody. So let's say if Prashant is a retired judge from the same high court as I am, and I had a fortune of, let's say, spending good 3 years with him in the bench, right? I have a dispute of 50 crores or 500 crores, and I want to appoint an arbitrator, and the parties say you can appoint whoever you want because we couldn't agree on an arbitrator. I would much likely appoint Prashant. Why? Because I will say that I know Prashant. He's been doing a phenomenal job at the court, and also I think he has had the experience of resolving a lot of disputes of that value. That's it. There's no roster, there's no pool from which I'm selecting Prashant. My only reason for appointing Prashant is that I have certain understanding that he will be suitable for this, and the fact that I know him. So it's a small network from which the judges would appoint, because there is no larger pool to appoint from. So there's no formal qualification that is necessary. There's no formal, the act does not say, or none of the rules say that there is a roster available to appoint. And therefore, it makes the system very, very opaque, right? And you think of it as a practical issue as well. If the judges in their entirety of their judicial career will know certain lawyers and certain judges who they have worked with or they have heard of, that is who they are going to appoint. They do not have a roster, they do not have a list of people to choose from. So it's a very opaque process when the courts appoint it. And therefore, it's a very narrow and, it's a narrow pool. Plus, like I said, that there's a wider discretion because the court can appoint whoever it wants. The judge can appoint whoever he or she likes. So in that case, it creates to a lot of discretion again to the judge's hand. If you go to the next slide, please. Okay, so we considered all of this and we decided to check what kind of resources are available. Otherwise for this, because when we started the research, we wanted to see if somebody else has discussed about it. Interestingly, there were articles that talked mostly from secondary sources which looked into Section 11 and discussed similar things, but there was no jurisprudence or literature that was available which looked at it from an analysis where they were actually looking at who was getting appointed, or they were talking to stakeholders about what was their perspective. Because it is one thing saying it based on what you'd hear here and there. Another thing, looking at the experiences of these lawyers or parties or other stakeholders in a court system and see what they feel of this entire system. So therefore, we saw that, and as per the studies available, there's only one empirical study which we saw was available. It was done before the 2015 amendments. We all know that the 2015 amendments and 2019 amendments were two significant amendments which are seen as very pro-arbitration amendments in India. But the study that was available was done by Mr. S. Badrinath in 2014. And the issue with his study that we found as a limitation, not an issue, it was a groundbreaking research of the time. But with time, that research was before, like I said, before 2019 and 2015. And so it was not updated. And the second thing was his research was based on a RTI-based model. So what he did at that point was he filed a lot of RTIs and asked Supreme Courts and the Supreme Court and the different high courts as to how they would appoint arbitrators. Was there a roster? By roster, I mean a list of people from which they would choose the arbitrator. To which I think he wrote to 15, and I think only 4 to 5 high courts got back. And in most of these cases, the high courts said that we do not have a roster, we are appointing based on discretion. So, and again, our issue was, like I said, that most law committee reports were precedent driven. So if you read any of the law committee reports based on arbitration, you will see that they are essentially relying on either judgments or on their committee members' perspective, right? So this is why we thought that it was good to have a qualitative plus quantitative way of researching, in which we would look at stakeholder interviews, we'd take stakeholder interviews on such issues, and also we would look at data from different high courts, right? Next slide, please. So, okay, I think some of I'll just give a brief outline. So what we did now was we took an interview of around 37, 38 individuals who belong from different part of the legal or the judicial setup. They were retired judges, they were registrars of institutions, they were lawyers, senior advocates, young lawyers, people who have been appointed as arbitrators, either retired judges or senior lawyers in certain or younger lawyers in certain cases. So we had a mixed bag of people who we interviewed. And the second thing we did was we looked into the last 9 years data from 2015 to 2024 for two high courts. We looked at the Madras High Court and we looked at the Bombay High Court. Now, the other alternative for us was to look at the Delhi High Court, but we did not go to the Delhi High Court for two reasons. One, the volume of cases. Delhi High Court has the highest volume of Section 11(6) cases, which, of course, the counter argument to which would be that why did you not take the most voluminous court? Because it would have given you a much better insight. But there is a problem with the Delhi High Court. The Delhi High Court will send most of its cases to the Delhi International Arbitration Center, which is a high arbitration center attached to the court. So therefore, if you look at it again from the outside, it's all institutionalized. But the problem here was, in our stakeholder interviews, we realized when we spoke to practitioners from Delhi, they would say that in most cases, the court would still appoint the arbitrator, but then refer the matter to the DIAC. Right. So even if it would look institutionalized, we would not understand what is happening inside the bench in every matter. Right. So therefore, we did not want to take that risk and form an opinion based on that. Whereas in Bombay and Madras High Court, which are the two other high courts with the highest volume of Section 11 cases, it made more sense because they had no such arbitration institution attached. So it was basically being appointed by the courts. Now, based on all of this material, we sort of found certain themes based on our research. The first question we asked is, who are the courts appointed, right? And based on that, both from the stakeholder interviews that we had and also on the data that we could get from the two high courts, we found that the courts, of course, overwhelmingly appointed retired judges. Now, it was also interesting that even within retired judges, the highest number of judges were not the Supreme Court, retired judges from Supreme Courts. The highest number of judges appointed were retired judges from the High Court. If you look at Section 11(6), the power to appoint rests in domestic arbitration, largely rests with the High Court. So it again tells you it is a question of networking and whether you know somebody or not. So because again, Supreme Court judges, if you're appointing, you have to know the Supreme Court judge. Most of the applications are coming to High Courts. The second, of course, was High Court judges and senior advocates who get appointed. The number, if you see, for technically qualified persons is very, very less for both High Courts. In fact, if I recall correctly, yes. So you'll see that in Bombay High Court, the technically qualified people is only 5 out of 106, 6 applications, which goes to a mere 4.72%. It's the same with the Madras High Court. Whereas if you see retired judges, it goes beyond the 50% mark. So you see that there's a pattern. Now, if I can go back to the slides, the earlier slide, you would see that some of our, so all this coded AIR 1, 2 is essentially the quotes from the interviews that we took. It says, and it was interesting when we asked people as to why do you think either parties are suggesting or the courts are willing to appoint retired judges as arbitrators, because there has to be other than just the mere networking or knowing somebody, there needs to be some reason to it, right? Why is a retired judge being appointed by the court? They say that they had arguments like, nobody wants to take a risk. If you have a dispute, you want the best legal representation and you want the best arbitrators. And in India, and this is quote unquote by one of the interviewers, they said there's a misconception that it is only retired judges or retired Supreme Court judges or High Court judges who are neutral. So there's that perception, right? Whereas if you look at the law and if you look at international practices, we have the conflict lists. We have Section 12 in India so that we can check whether their conflict exists or not. But the perception in reality differs with regards to parties and the court. If you can come to the next slide. So another stakeholder again goes on to say something to the effect that there's an obsession with retired judges. And this is, I mean, with our understanding, what we realize is both courts and parties would prefer mostly a retired judges being appointed. So there would be two situations, right? Even under section 11.6, you would either go for an appointment of a sole arbitrator or a three arbitrator panel. We realized that when it was a sole arbitrator panel, again, much like it, the court would appoint a retired judge. When it was a three arbitrator bench, and let's say one party has recommended a name, and the other party has either failed or has also recommended, the court needs to appoint either the third arbitrator or the second or the third arbitrator. In that case, it's a situation of FOMO, right? So for instance, again, let me take a situation where Prashant and me are two parties. Let's say I nominate a retired judge as an arbitrator, and now Prashant has to appoint somebody, and then the court has to appoint somebody. Now Prashant, let's say, sees that I've appointed a retired High Court judge as an arbitrator or Supreme Court judge as an arbitrator. In that case, the first thought that Prashant would have is, if Animesh is appointed a retired Supreme Court judge, if I appoint, let's say, a lawyer from a High Court, will the High Court lawyer, and this is just about perception, this is not about forming opinions, will the High Court lawyer be able to negotiate on the same table with the retired Supreme Court judge to give a judgment? Because at the end of the day, even when two arbitrators or three arbitrators are discussing, they are also negotiating as to how they should form an award. So that is also something that we thought, that came across different stakeholders when we interviewed. They said that there's an obsession because they feel that it is only the arbitrator of the similar stature who will be able to come up with such negotiations on the table when they're negotiating, right? So that is one thing that we came across. Then there's this other perspective when we interviewed people from the technical background. There was an argument that was being made that in most of these cases, there's a two-sided argument. Many times parties would simply, or courts would simply feel that if it is a legal matter, how would a technically qualified person help, right? And therefore they would not appoint a technically qualified person. Whereas in our experiences of speaking to technically qualified persons, we came to a conclusion that while they face certain issues in complicated matters, in most cases for them, the process was not too complicated to not understand. And we came across a few of them who had done significant arbitrations, but then again, they were not appointed by the court, they were appointed by the parties, right? So that is again one assumption, I think, which is quite prevalent in India. Whereas if you look at internationally, in many situations, in many lists of arbitrators, if you go to the ICSID list, if you go to any institution in their list, you will see that there are a lot of technically qualified persons who are appointed as arbitrators. For instance, you will see architects being part of construction arbitration because they have a better understanding of how a construction takes place. And in many cases, they actually advise the other arbitrator. If there's a co-arbitrator who's a lawyer or retired judge, they would advise them as to how this happens. So you'll see all those different sorts of different technically qualified people becoming very significant to such dispute. Next slide, please. Okay, so now that we have discussed about the fact that most of these people who have been appointed are retired judges, the immediate question, and it's a question that was being thrown to us a lot of time, as to what is the result that, as a result, what happens if they're appointing more and more retired judges? Why should you be bothered, right? So there are a few arguments to this. First is what we call as, it's a judicialization of the process. We have to understand that fundamentally, the idea for arbitration was to get out of court, right? And to adjudicate a dispute both faster and also sort of outside the technicalities of court. And one complaint that we felt that was given throughout, I think, almost all interviews, was that when you appoint somebody who comes from such an adversarial system, they would want to follow the same process. So what would happen is, in arbitration, you do not really need to follow the CPC procedure to tooth and nail. But because a judge is coming from that background, they would want that. We in fact had in our interviews, we came across instances where the party representative would say, like, it's so difficult to have a retired judge because they would dismiss a certain application we would make because it did not adhere to CPC. But CPC is not something that needs to be tightly followed in such a situation. So that judicialization of the process is a problem. The second huge problem, I think I'll just jump to correlate at this point, is that when you're appointing from the same pool of arbitrators, right? It's a situation of I scratch your back, you scratch my back, without trying to be politically correct. What would happen is that because you are creating you have more demand for the same people, it creates higher cost. And cost, as we know, for the last few years has been one of the bigger concerns, at least in arbitration relating to India. And also thirdly, because again, you have higher demand from a smaller pool, they have to manage their timelines, right? And because they cannot manage their timelines, because they have more appointments, so it delays the hearings. So therefore, the timing for appointments would go on, for the entire hearing process would go on increasing. In fact, I don't know in which, I think we'll come to that slide a little later, but one of the interesting insights that we got from a practitioner, in fact, a senior practitioner, was when he said that he came across a retired judge who had something around 56 ongoing arbitration at that point of time, right? And he somehow, because of his engagement or her engagement with the arbitrator, came to know of that particular arbitrator having a lot many arbitration, and that's a point he made across the court. And the court said, if this guy can, or if this woman can, have 56, why can't they also deal with 57? So that's the kind of work distribution that happens. The second problem with the court's approach of appointing, and largely, is that the court, unlike institutions which we look into, they don't do due diligence of how many appointments they have given to somebody, right? Also, I think this is also a systematic problem, because let's say if I'm a judge at the Madras High Court, and if somebody else is a judge in the Bombay High Court, if I have appointed Prashant as a arbitrator in this particular case, and somebody else from another high court has appointed Prashant as an arbitrator in another case, each of us will not know, because arbitrator's appointment is supposed to be confidential, right? Unless in certain cases, of course, the order would be visible, but very few will actually make the effort to come across and say, okay, I'll read this order, who's been appointed every day. So there's also that lack of due diligence, which otherwise you will see in a more systematic institution, where they will keep a record of who has been appointed or who has not been appointed. And therefore, we also see that the same kind of people are appointed, same kind of people with same background is appointed, and therefore you do not see the multicultural or multidisciplinary representation in such appointments. And this representation is in all aspects. It's not just with respect to the qualifications, but also with respect to geography, with respect to gender. You will see it in all sorts of aspects, right? That there is lack of representation in the appointments. Can we go to the next slide, please? And I think this largely I have dealt upon, that how would courts appoint? Really, they would not do much of vetting, because you have to understand, and I think this is also the larger point, that this is not the only function of court. We know that there's a large pendency in Indian courts, and to be fair, there's a huge volume of tasks that every judge in a court has to do. So Section 11 is just one of many things that they have to do. So there's not really, or there's no particular group of individuals who would vet the kind of people who should be appointed or should not be appointed. So I'll give you, for instance, an example. Let's say in an institution, if somebody has been appointed as an arbitrator and there's a bad experience with that arbitrator, the institution will flag that, right? That this person has had problems in the past. But once the court appoints, the court will have no record of whether that's happened or not. Even if that is the case, it will come to the court after a very long time, once the party files an appeal once the award has been given. So in the meantime, the court might appoint the same person 3 more times. So there is also that particular problem, that there is no vetting as to whether a candidate is good for the parties or not. And again, I come back to the fundamental issue that arbitration was meant to ease parties at the point I mean, at every point of the decision making process, right? So that's again another huge problem with the courts appointing without proper vetting. And also, I think the system, it is very intriguing, some of the insights which we came across on how the lawyers, how the arbitrators would be appointed. You would see that almost, if you look at, I mean, in our data, we saw that there was familiarity with the kind of location as well. For instance, if the only other large subset or set of data we had other than judges being appointed is that in certain smaller disputes, by smaller I mean, let's say a 50 lakh or 2 crore dispute or 5 crore dispute, where certain lawyers would be appointed or senior advocates in higher volume matters would be appointed. Now, if we look at the location of most of their offices, right, it's interesting because they would be appointed from, so these people would be essentially people who are practicing in that high court, which again brings me to the question that these are people who are appearing more and more in the same, before the same bench. So how the courts, in one of the stakeholders, how they express this entire process is that the court will be impressed with somebody. Let's say if I am appearing before the court and they're impressed with the arguments that I'm making, the court would essentially say that, okay, I like this guy, he makes good arguments. Parties, would you agree for this person to be appointed as an arbitrator? So that is the due diligence in many cases, right? Of course, if on the face of it, I feel that there's a conflict because I might have represented somebody, I point it out as per section 12. Of course, that conflict check and everything has to be done. But other than that, there's no qualification or anything as certain by the courts while appointing. So that's also another process with how rigorous that process is, right, with respect to court appointments. Next slide. So I think I've sort of also done this, that there's no standardized process. So that's a huge problem. And the issue with this is, it's not like that we are talking out of thin air, right? Because if you look at the 2015 amendments and the 2029 Law Commission reports, not the amendments, but the committee reports before the amendments, they also recognized all of the issues that I'm sort of pointing out one way or the other. They've talked about higher costs. They've talked about more time being taken for completing arbitration. They talked about the fact that there needs to be a roster. There needs to be an institution who does all of this with more transparency. But however, the amendments show otherwise. So that's the problem with what has happened. And that's, I think our data is only sort of making that argument forward that, okay, there's a problem that you need to solve. If I can go to the next slide. Yeah, again, I think this is something that I have touched upon already. Yeah, one more interesting bit of insight that we had is that sometimes parties in a 3-member bench, arbitrator bench, or let's say where the parties are recommending, they would actually want a retired judge as an arbitrator who's a busy arbitrator, because like I said, it does two things. If the other party is let's say on the verge of insolvency or does not have that much money, they would feel that they cannot afford that arbitrator and every hearing would get expensive. So they would want the other party to at some point come and negotiate with them. So it's also one of the guerrilla tactics that they would use to either increase the timeline for arbitration or just finish off the arbitration and negotiate and finish. So it as soon as possible by negotiating at a lower value. So those are the kind of patterns that emerge when you look at the kind of appointments that are happening in India. If we go to the next. Yeah, so we also found as a part of the whole appointment process that many times the fees that is allotted is based on status. So, and it's very interesting. So there are two aspects to it. First is the fees. So we of course have if we look at Arbitration Act, there's a fee schedule, which you will see that in many cases in our stakeholder interviews, they said that if you are getting into any of this famous arbitrators, they would not follow it. So they would charge much more for the time, and which is, of course, they are free to do that. It inflates the cost, but then the parties have agreed to that person. But at the same time, these fees had to do with the kind of retirement they had when they retired from their job, right? So that also again inflates. And if the court sort of it's fine as long as the parties are doing it, but if the court is appointing somebody like that, it again goes on to the detriment of the parties. So that's again something we found out, and we found out that in a lot of cases one party is not willing, but because the other party has agreed and the court has suggested somebody, they have to go with that person, because remember, that person will end up becoming the arbitrator. You cannot have a claim against the arbitrator just when the arbitrator is starting. It's just that you're starting the arbitration on a bad note, and you wouldn't want to do that. So that's also another problem we came across when we spoke to parties. Next slide, please. Yes. I think I've dealt with this as well. Yeah, I think this also I have sort of looked at. We'll go to I think we can go on to the procedural rigidity part and on the neutrality part. Yeah, so this I talked about, right? So in a lot of instances, our stakeholders have also talked about how there is that demand for things like the CPC or the Wakalatnama or rejoinders, which are not necessarily something that they need to follow, but they follow it because they come from that kind of a setup. And also, I think one other part that I think Prashant has also been separately working on is the due process paranoia part, where the arbitrators, you have to also understand, come from a setup where they fear for their reputation, and they want all of this to be followed because they have a paranoia that tomorrow the award must not be challenged because it brings in bad reputation to their name. So they want everything to happen by the letter. So that's also one issue with it. If we go to the next slide. Okay, now the other side of it. When we took most of the interviews minus the numbers, we asked the stakeholders as to what do you feel? Have you had experiences of a separate pool? Because it is one thing arguing, saying that, okay, so and so people are appointed, but if they're giving the results, why should it matter, right? It's like saying if a certain cricketer, regardless of how much money they're taking, if they're actually giving you the result, why should you be bothered, right? But they said quite the contrary. They said that even when they had people from, let's say, a technically qualified person or a younger arbitrator who was taking lesser fee, the kind of experiences they had was also as good, right? So while there was an overuse of the usual suspects and there were delays and bottlenecks which they experienced when it comes to the regular people being appointed, a newer lot of people, when they were appointed, they had actually a much smoother experience. This we came to know because of smaller disputes. And when we spoke to by younger, I mean still lawyers with 10 to 15 years of experience, who have now started getting appointments as arbitrators, and both their experience and the party's experience with them were better. So it's not like when you're appointing somebody, the experience deteriorates. So that's again something that we sort of figured out from the stakeholders. Can we go to the next slide? Okay, I think we're towards the end of it now. Now, I think what we also try to look at is, considering that the INCITRAL model law is quite similar to, the Indian law is quite similar to INCITRAL model law. So we were curious to look at how other jurisdictions are doing it, because most other arbitration-friendly jurisdiction will have a similar sort of a law as well. So we looked at Hong Kong, Singapore, and UK. And we found something very interesting, that in many of these institutions, and in fact, for the Malaysian example as well now, what we have found that while there is a similar provision, in most cases, the power of appointment is given to one institution. So which is what, if you look at 11.6, the Act wanted to do, but has not been able to achieve. So because they are doing through an institution, so there is less of any of these challenges that we have so far discussed, right? In UK, it is extreme, where the courts will essentially not enter at any stage of it unless there is an irrevocable breakdown of consent between the parties. There's in fact a very recent judgment which we also look into from the UK courts, where they agreed to not interfere with two parties and their arbitration agreement because they felt it was not yet irrevocably broken. So that is how pro arbitration they are. Now, what are some of the benefits. So what happens in most arbitration institutions around the world and international arbitration institutions around the world is that while the director will appoint, you will have a secretariat who looks into the entire the appointment process, right? So usually they will do a due diligence of candidates across for every matter that comes to it. If you take the AIC's example or the Singapore institution's example, the secretariat will vet CVs of all the roster. First, they will have a roster of people. So for instance, the AIC will have a roster of, let's say, around 1,200, 1,500 people for a certain type of arbitration, right? So from that, for every type of arbitration. Now, let's say if there's an expertise with somebody on construction arbitration, for a construction dispute, they will try to get somebody for that kind of a dispute. Then they will run a check with them if there's some kind of conflict with such people. Once that is cleared, then they will go to the parties. They will say, look, we have this 7 people who we think might be good enough for you. Would you want them to be appointed? Then the parties will come back to the institution saying that, look, okay, out of this 7, maybe we can go with 3, and then they will number them. And out of those 3, the highest numbering that happens from that list will end up becoming the arbitrator in that particular case. So that's the list procedure. It's not just common to institutions abroad, but I think even the MCIA follows something very similar. The IIAC in India has a certain similar setup as well. So it's not like the practices are not there. I think it's a lack of intent on whether the courts want that power of appointment to go to institutions or not. I think our last bit of the slide where we talk about one interesting part, I think, and if you see, this is what I said, that the ICC uses a list method. MCIA, when we looked into it, we saw that there were certain, they actually were more mindful of appointing newer arbitrators or arbitrators other than retired judges in such cases. And they actually understand this, that when parties want to go for any of this institution, it's business for the institution. So for them, it's not one out of the 200 things that they're doing. So they have to look for transparency and for efficiency-driven system. So that's why it becomes important. On the last bit, it's just that when we spoke to all of this institution, I think it's there in the last slide, where when we looked into it, we saw that there was actually intent from the institutions as well. There was a joint letter that was written by many institutions in India. The Nani Palkiwala Arbitration Center, the MCIA, and the IIAC from Delhi actually wrote a letter to the then Supreme CJI and the court in general, saying that there needs to be fair delegation of appointments in such cases, because that is the most transparent and efficient way of doing it. And I think that's what has been our understanding as well. But a part of this research is also largely to show why as a court you should not appoint, because we already know that institutions are more robust. But the larger question is, why is the court appointing and why they should stop appointing? So that's, I think, largely what we have been trying to do. I hope I didn't take more time than that was allotted. I'm so sorry if I did, but that's largely what we wanted to do. Over to you. Thank you.
Thank you. Before we conclude, I'd like to open this up for questions. So if anyone has any questions, please feel free to unmute and ask.
Can I ask a question?
Please.
Animesh, thank you so much for talking about this. It was very insightful to learn about how this plays out in practice. I just have a question on the issue that you illustrated about the capacity constraints on the kind of people that are appointed. So they're usually picked from the same pool of people that, say, judges already know, they're retired judges. They have too many cases that bottlenecks the process. But we also know that courts currently have a huge capacity problem of their own. They themselves are constrained in terms of expertise, they're constrained in terms of money, resource. Is this, in your view, what do you think that, considering the state at which the court system currently is, what can practically be done about this? And that's on one hand. And I think an offshoot of the same problem is we see this kind of favoritism happening within the judiciary itself. So we know that this is how the medium works, and this is how it's been rigged for very many years. It's the very nature of the beast we're dealing with. So why would we expect that they would treat arbitration any differently in terms of favoring their brethren over anybody else? If you catch my drift.
Yeah. Yeah. So I think the answer actually to the first question that you asked is out. I mean, it's something they've tried to do already. For, like I said, that in 11C they do say that any other institutions designated. So technically, the courts have the power to designate an institution to make such appointments, and that's the law also sort of hints towards that. It's another thing that they have not done. So there's the intent part of it, right? Like I said, I mean, the reason we did not choose Delhi High Court was because Delhi High Court has annexed arbitration center. So they essentially, any arbitration application that is coming, they can send it to the institution saying that, why don't you just deal with it? But the problem here also is that while the institution can make the appointment, they don't do it. It's mostly either the High Court who does it and then sends the matter over to the DIC, or even if they are sending, we do not know how they're appointing. So that's I think one part. Prashant can, I think, explore more on that, because from what I recall, I think that's one challenge we had as to understanding how they are appointing, if I recall correctly. To the second point, right, I don't think it's a question of resources, because it's not like handling 11.6 is giving them more money as a court. But I also get what you're talking about, why they would want to not do it at all, right? Because ultimately, okay, I mean, I do not have a correct way of putting this, but ultimately, because they have the power to appoint, they have a power to choose who they want to appoint, right? So if you are my friend, I know that you're going to retire. I know that going forward, I can give you more appointments. And it's a process, right? And tomorrow, if I retire, let's say Prashant or Vishnu, if they're in the bench, they know that I'm there. I have expertise by becoming a retired judge, so I will get appointments as well. So if I do not appoint you today, I take the other way around. Tomorrow, I will not get appointments. So they don't want to take that out. It's also a good way of getting more appointments. So yeah, so I think that's a challenge. Whereas in an institution or in any of these institutionalized forms, I think if there is a group of people who sort of do it, in that case they'll vet more, right? For instance, if you have criminal law experience and there's a commercial law dispute, there are chances that there might be a candidate who's a senior advocate might be better placed than you to be appointed. But who's doing that vetting here? So that's, I think, so they don't want to get the power of appointment because that's a power they enjoy. So yeah, I hope I've been able to just.
If I could add to that, I think to your point about capacity, so there are, possibly two ways to look at appointment from a judge's perspective, a sitting judge perspective. So they would either go by meritocracy, but for that they would need capacity, because they would need a pool, they would need some objective standards.
Yeah.
That would take time and resources to sort of create a list, etc. The other way, even if they are, so we are not saying they're necessarily corrupt, but they would go by trust, whoever they trust. And so who would they trust? They would trust their peers, people who have they worked with earlier and now they are retired, or even the lawyers who come and argue before them. And now senior lawyers are not necessarily interested, because arbitration doesn't give them, it's an opportunity cost, the trade-off between what they'll earn as a senior advocate versus what they would have earned as an arbitrator. So they are happy doing their litigation work, so because they earn relatively more. So they are not interested so much in arbitrations. Senior lawyers may not be interested. So between lawyers, district court judges, technically qualified persons, Supreme Court judges, High Court judges, there is an unsaid hierarchy, which is that if there are low stake claims, then the court is happy giving those opportunities, pass on those opportunities to, say, lawyers or retired district court judges, or sometimes even TQPs. But if it's a high stake claim, then the matter often goes to retired judges, retired high court judges, and sometimes also Supreme Court judges. And the parties also play a role there. They are also happy, as Animesh also elaborated, because if one party does that, then there is pressure on the other side also to appoint
Person of similar stature.
to kind of counter. Yeah.
Yeah. Well, it seems to me that it's a plague that sort of haunts the courts in any case, and I don't see an easy way out of it. It's in the culture. It's in the organization.
So the easy way out is actually easy, which is that there are two sort of consumers of arbitration. One is the private firms or private companies, and the other is government. And government alone has very high, large chunk of arbitration disputes that often go to, because government, PSUs were appointing their ex-employees, etc., and there were judgments that have not discouraged appointment of former employees, etc. And so now many of those disputes pertaining to those contracts have landed up in Section 11 before the courts. So good practice would be to amend those existing contracts, and the government and PSUs, make that resolution that they would be using institutional arbitration and mainly a robust private institution rather than going to court and ex centers, etc. And so a large number of the disputes would be
redirected.
Yeah, redirected to then private arbitral institutions.
Right.
I think
Hopefully
just
soon.
just one bit on that as well. You see, on the institutional part, the problem also is that many of the Indian institutions, you see, Indian parties want to come and arbitrate in Singapore or any of this other jurisdiction. Why? Because they see that Singapore, now Dubai, they have a lot of cases going where Indian parties are going. But if something of that effect that Prashant says is done, let's say where they say that, okay, the government designates an institution that, okay, this is an institution where you can refer to, and more and more parties start referring to that institution, it builds more confidence, right? So then they will have large volume. And any institution which is recognized today, their point of recognition came from domestic arbitrations. Once the domestic parties have, sort of established that confidence, then only will international clients come. I think we sort of jumped that ship where we feel like we'll become a hub for international arbitration, whereas at first we have to become the hub for domestic arbitration for ourselves and not ad hoc but institutionalized arbitration. So that's also, I think it's a systemic process. It has to start from the point where Prashant said that government has to start sending its disputes to arbitration.
Right. Thank you. That was very helpful.
Yeah,
I also have a question.
yeah. It's hi. This is Manik.
Hi, Manik.
Hi, Animesh. It's been a while. How are you?
Good. How are you?
Very well. Anyways, it's not not a question. It's more of a supplementary to what you said. As far as the appointment of arbitration is concerned, so Delhi High Court in particular, I can say it from my particular experience. We've had instances where appointments have been challenged before the Delhi High Court, and you were right. The systematic procedure is you go to the arbitrator, you file a 16, you have no other option to appeal, and you await the order. But we were fortunate enough to make up a case wherein we challenged the appointment in a writ petition. And fortunately, the High Court took cognizance of it. We got a stay. And it was just one matter. It was, I believe, 4 or 5 matters in which we were able to get a stay based on a writ petition. So while the courts are primarily discouraged from interfering by virtue of Section 5, of course, interfering in arbitration and its proceedings, there have been instances where again, I'll say from personal experience, where court have actually interfered, and we are expecting a favorable order also in those cases. So yeah, we as in parties are not primarily openly remediless, but yes, they have to make a case for the courts to interfere under the writ petition. So that was something very novel which came to my knowledge also. And since you mentioned it, I thought I'll just share it with you. This is also.
Can I just add to what you said? So I was just thinking today for this, and I was speaking to a few of my other colleagues from the Delhi High Court as to asking them what other things could you do in such a case. One of the, they never did something which thankfully now you said you did. One of the other way of going about, they said, was through a writ petition. But
Right.
after they said the word writ petition, they all took a second to say whether we can do that or not. I mean, I'm very happy to know that that's something that you have tried to do. But again, I mean, it deletes the entire purpose of going for arbitration.
Yes, I agree. But again, ours was a very peculiar case. So
And
the
I think you'll
court-
also have to have, because when you're going through that writ petition case, you have
Right.
to also have probably very strong grounds for that writ
Yeah, I
petition.
agree. I'm totally
So-
with you on this. In fact,
Yeah.
Justice Pratibha Singh was the one who gave a judgment of, I think, Sudhir Balotia or Samir Balotia. I'm forgetting the entire name. It categorically gives out different pointers in which the High Court will interfere in a writ petition, especially for appointment of arbitration. So that was quite an interesting case that we had. And you're right, we had very strong case. I will not deny that fact. But my point is that the courts have not shied away from interfering wherever they thought that it is actually required to do that. So no, that is one asterisk you can add to your
Please send your judgment or order whenever
yeah,
everything
judgment
will be happy.
is yet to be pronounced, but I'll send you the orders for sure. That is for sure.
Thank you.
Yeah, thank you.
Any more questions?
Yeah. Hi, Animesh. You mentioned in the slide somewhere that there are people who are handling around 50 to 60 arbitrations at once. And obviously that leads to issues around delays and costs. And you also mentioned about the perception problem that people would obviously want to appoint more reliable and more people who have a prominent presence in the litigation or who have been high court judges as their own arbitrators. So do you think that there can be a formal cap on the number of appointments, on the number of arbitration that an arbitrator can take? And if so, do you not think that it would meet the same fate as Schedule 4, like a toothless tiger? It will be there, but still not enforceable.
I mean, it's difficult, right? Like I said, it's how will, if it still continues like this, how will the Delhi High Court know who Guwahati High Court is appointed? So they have to keep, so somebody has to keep a tabulation of it, firstly. Secondly, I don't see, I mean, such a number as, I mean, if you create a sort of tap saying that, okay, we'll not give this many, I don't think that will be, I don't personally see it as a solution. What solution is, like I said, that having an institutionalized form of it will anyways be the solution, because then you will know all of this, right? You will know how many appointments has been given. You'll know what is the volume of or quantum of sort of dispute that is given to an arbitrator, and all of this will be resolved by one act itself. So I don't think that, and like you said, that even if there is a provision to that effect, I'm very unlikely that anybody would accept it. I mean, I'm happy to be proved otherwise, but I don't think so.
Right. That's it. So thank you everyone for attending. Before we exit, can I request everyone to turn on their cameras so that we can take a photo?